from the perspective of the police. The board selected this topic in recognition of the growing push for greater accountability from law enforcement agencies. This is a subject in which we should all be deeply interested because of its effect on our personal lives, but as well as collective bargaining. Attorney Christopher Green has graciously agreed to discuss these issues with us. Attorney Green is an associate with Crabbe, Brown, and James. He is a graduate of The Ohio State University. He trained at the local level in public sector, federal level under a United States District Court judge, and later in the private sector with the focus on labor and employment matters. Again, thank you, Attorney Green, and I'm going to turn this presentation over to you.
Thank you, Amita, very much. I'm excited to be here, excited to have this conversation with everyone. I think it's obviously an incredibly important topic, just given the current state of everything that's been going on. Amita, am I able to share my screen here?
Yes, you are.
Okay, let me see if this works. Can everyone see the PowerPoint that I have up here? That come up? Okay, great, excellent, thank you. See if I can make myself a little bigger here. Okay. So again, just a little background on who I am, more so who my boss is. It's probably more interesting to all of you. So as Mita said, I'm an associate here at Crabbe, Brown, and James. We're based in Columbus, Ohio. I grew up in Columbus, Ohio, went to Ohio State for law school and undergrad. I'm a litigation associate primarily on our litigation team, but about 30, 40, maybe 50% of my time sometimes is spent as associate general counsel to the National FOP. That's the largest police officers union in the country. We have about 356,000 members across 2,100 lodges. My boss is Larry James. He's general counsel to the National FOP. He's held that position since 2001. So I've been training under him for the last several years, working very closely, kind of his right hand man in a lot of what's been going on. I've gotten, as you all are aware, in the last 2, 3, 4 years, it's been trial by fire for me, but it's been great representing the FOP again on the national level. I presented our legal counselor seminar and our labor summit every February or March. We hold that in Las Vegas. I do similar presentations such as this. We present on a number of different topics. Today, I'm going to cover about 3 or 4 different kind of like hot button issues that are out there right now in terms of police reform or police modernization. But again, this is from the perspective of the National FOP. One of my other primary roles is drafting amicus briefs on behalf of the FOP. So any major policing issue that might go before any of the circuit courts, sometimes a state court, depending on the issue, but especially the U.S. Supreme Court. We've done 9 since 2018 and 8 have been to the U.S. Supreme Court. I'm actually, just before I logged onto this, I'm working on another one that's in the 6th Circuit dealing with qualified immunity. So I am kind of in the trenches a little bit when in terms of kind of the broader understanding of what police reform might look like moving forward. So I'm here today again to talk about police reform from the perspective of the National FOP. Despite whatever narrative is out there a lot of times, whatever you might hear or read, I'm here to tell you today that police officers, and in particular the FOP, does not oppose reform efforts. I want to read a quote before we get started. This is from the National FOP president, Pat Yos. He gave an interview to NPR last summer, and this was his quote. He said, "We have emotions that are so high on both sides of this issue, and in the middle, there's an area where we all agree, and I'm confident that we all agree that we need to have some reform. We need to have some discussions on how to improve what we're doing." And so that tells you kind of exactly where the FOP stands on this. And so I'm here today, hopefully to kind of further that discussion and touch on a few things, and hopefully have some good question and answer period at the end here. So these are kind of the 4 topics that we'll discuss today. This is kind of our roadmap here. The first is just, we'll briefly touch on just like what the current law enforcement related reform legislation looks like across the country. The second, we'll talk about civilian review boards, including the different types, how cities are implementing those, and I'll address in there kind of what role the union plays or can play. The third topic is just kind of a broad overview of what collective bargaining and arbitration means for law enforcement. And this is where we'll get into kind of the delineation of power between unions and management, and cover really what unions do and do not do in the law enforcement context here, which again, I think gets lost sometimes in the broader discussion. And the last thing we'll talk about is the very sexy topic of qualified immunity. It's something that I don't know that a lot of people knew what exactly it was a few years ago, and now everyone seems to think they have some sort of an idea of what it means. And so I'll kind of go over what it means, and from a litigator's perspective, but also what it means in terms of moving forward in the law enforcement community. So 2020 was really the ignition switch for a lot of this. I think we all remember what that was like. In particular, George Floyd's death really sparked a lot of the current discussion and current narratives that are out there right now. There was riots, protests, calls for defunding the police. And then we had January 6th as well, which was a turning point. So just kind of all of that kind of keep in mind with what sort of started a lot of the current discussions that we're having right now. If you look, at 2020, it really, one of the things that it did was it spurred legislation across the country, particularly aimed at law enforcement. I have some numbers on the screen here. The National Conference of State Legislatures, the NCSL, has a database. I encourage you to go out on their website, and it tracks legislative responses to policing. And this is the source we used here to get these numbers. It tracks all law enforcement related legislation that has been introduced in all 50 states and Washington, D.C. since 2015. And you can see kind of the numbers here in 2020, what those numbers look like. And then, they've increased, 2, 3, 4-fold in some cases in terms of the amount of legislation that is being introduced related to law enforcement. The different types of legislation, there's use of force and discipline. And that legislation really deals with regulating the type and amount of force a police officer uses and the investigations or procedures to access an officer's discipline. Use of force legislation usually deals with things like deadly force, excessive force, less than lethal force, chokeholds, duty to intervene, duty to report, things of that nature. There's also legislation that's been introduced involving training standards and certification. And that legislation really regulates the officer's qualifications and conduct. So training legislation, things like requiring initial training for certification, reoccurring training of topics, including use of force, de-escalation, interactions with individuals with serious mental illnesses, which is an ongoing discussion that we've been having as well. Responses to different offenses, domestic situations, sex crimes, hate crimes. So legislation aimed at the training that's required for those scenarios. There's also been legislation introduced with respect to technology and data. And that legislation really regulates the use of technology. So think like body cams, the method the data is collected and distributed, Also deals with like facial recognition software, things of that nature that are being introduced across the country. And then one of the last ones is policing alternatives and officer safety and well-being. Again, this addresses issues around police reform and the mental health of police officers, policing alternatives and collaboration legislation, which is, legislation authorizing and funding alternative responses for law enforcement, which is, think about like collaborations with behavioral health, social services professionals, things of that nature. So to kind of summarize it all as it relates to legislation that is introduced and how the union or the law enforcement community might play a role, from the union's perspective, they simply want a seat at the table. So as I kind of said in the beginning, the law enforcement community, the officers themselves are not there to stymie reform efforts. They want to be consulted in a meaningful way. If you're implementing, legislation that's going to impact how they do their job, I think it makes sense to include them in those conversations, to have them come testify before the committee that might be introducing the legislation, to hear what they have to say, to hear suggestions they might have for the legislation. I think about it from the perspective as an attorney. We are incredibly protective of the legal profession, and we are, anytime there's a change to the rules of civil procedure, for example, we kind of get up in arms about it. We submit comments, we do things like that. If there was an effort to reform the way that we practice law, so again, like I said, a change to the civil rules, we ask attorneys for their input. We ask attorneys to submit comments, to have an opportunity to weigh in. And that's the sort of the kind of give and take, that back and forth, that I think, as from the union's perspective, we encourage the legislatures to adopt. So part of the call for change to policing in the country is for more civilian oversight of police. And to be honest with you, I don't necessarily know that this was something that was on our radar before, George Floyd's death in 2020. I don't think that it was something that we were really looking into too hard, at least from a national perspective. So what we did was we developed a task force. And as soon as we started hearing things like, well, there needs to be more civilian oversight of police, there needs to be independent bodies reviewing, how officers do their investigations and discipline and things of that nature, we said, okay, what does this look like across the country? And what we found out in our research was that it's city dependent. It means different things for different cities. There are various models of civilian oversight, and these are not new in any way, which sort of came out as a surprise to me. I thought maybe this is, a relic of the 21st century or something like that. And they're not. They've been around in many circumstances, since the 70s, 80s, 90s, these kind of independent bodies. In many jurisdictions, especially in like those with the top 25 largest police departments, I think the numbers like 19 or 20 of those 25 cities have some sort of civilian oversight of police. So the issue is not necessarily in their existence. The issue, I think, is in how they're working, and it's just that they're not working. And so what we did was we kind of studied the different types of these bodies, and I'll go through some of those, and we developed kind of what, if we're going to say, okay, we accept that these bodies are going to exist and maybe they should, but what's the best way? How can they work the best? And so we made some recommendations for a civilian-led police review commission. And in developing that model policy, we really considered things like who should make up the board, what sort of training, if any, would be required for these individuals to serve on the board. Would there be law enforcement presence on the board? How do you fund the board? What sort of resources are going to be available to them? Do they have the ability to issue subpoenas? Does the board have the ability to issue discipline or conduct its own investigation? So that's kind of the types of issues we were thinking of when we were developing our model policy. And when I say we, I'm talking we, again, this was a task force that was made up of probably 9 to 12 lawyers from across the country that really deal with, representing police officers and have been involved in, to some extent, in the national FOP level for some time now. And it was led by again, my boss, Larry James, the general counsel. So these were the three main types of boards that we really looked at. The type that the national FOP landed on as a model for best practice was the third one on your screen there. It's the audit model. The audit model allowed for a board to kind of review investigations that had already been completed by the department itself, and then make recommendations on various policies and practices to promote kind of that systemic change. So for an example, if there's a broad trend in certain cases or investigations that's recognized by the board, so say they look at 30 cases that have been investigated over the last, year or 2 years, and they say, wait a minute, in 20 of these cases, we're noticing this same issue keeps coming up, or this same, practice is apparently an issue before us. They can then recommend a change to that practice to the department to say, hey, look, we audited your investigations over the last, 30 or 50 investigations, and we noticed this pattern that you have. Here's a recommendation to a policy change that we might have, or a practice that can be changed within the department. And so that's sort of where, if the ultimate goal is true reform and not to punish an individual, then I think the audit model and what we landed on is really the best way to accomplish that overarching goal. And as I said, each type of civilian-led body had certain strengths and weaknesses. I want to talk briefly about just some of the weaknesses that we had noted in each of them. So the investigative model is where they have kind of independent authority to investigate and review individual allegations of police misconduct. In certain circumstances, they may have the ability to discipline as well. What we determined was that's likely going to be the most expensive model for a city to implement, and it's also going to be pretty complex because, again, they're conducting their own investigation. So in smaller cities where the resources and the budget are not what it's like for a city like Columbus or Chicago or New York, that model probably doesn't make sense, and they probably don't have the resources to implement a body like that. We concern about the lack of expertise that may be involved in that sort of investigative body. If they don't have the right people on the body in terms of, do they have anyone with any sort of law enforcement background, or do they have the ability and the knowledge and the understanding, the experience to really investigate these sorts of allegations? That was a concern as well. The review model, because they're reviewing individual case investigations, a review-based body is reactive in nature, right? Because they won't be able to create any sort of long-term changes to problematic policing practices. And especially if they're comprised of volunteers, which a lot of times these are not paid positions to be on these boards. Again, that lack of expertise may result in them having to lean on the department, which then kind of feeds into this pattern of reducing independence overall, which kind of defeats the goal. The audit model has its own weaknesses as well. One of them that we noted was, examining broad patterns as compared to individual complaints. might get pushback from the community, because each time there's a high profile case that gets, captured by the news media, the body is going to be called upon to do those investigations by the public. But in an audit model, they're not investigating those, singular incidents. So then you may get some pushback, some skepticism from the community, because the individual cases aren't the focus of the audit model body. So how can cities implement a civilian review board? There's three main ways that we've kind of determined that these review bodies are being implemented. The first is through executive orders. That's done without a vote by the public, simply signed into law by the mayor. Tampa, Florida was one of the major cities that we saw establish their review board by executive order. They did that back in 2016. Standalone legislation is probably the most common. They are multiple outstanding today in terms of legislation that's been introduced. Philadelphia is an example. They have legislation out there to create a new civilian-led body. Charter amendments are also one of the ways that are being utilized. And these are ballot measures that are submitted to the voters of a city, and then they're implemented into the city charter. This is how the city of Columbus created its civilian review board that is not fully implemented yet, but still undergoing kind of that initial phase. So again, what role can the law enforcement union play here? So when the city comes to the union or to the officers and says, look, we're going to implement a civilian review board, or we're going to alter our existing board, there's likely going to be a commission that's put in place, or some sort of a committee that's going to be put in place by city council to make suggestions to policies, determine roles, things of that nature. The role the union can play really is to request that there be law enforcement representation on that commission that will be installing the review body. Again, I don't think the role of the union is to outright oppose the body itself, but just encourage that they want some sort of representation on that board or that commission that's implementing these policies. So that way the voice is there, and they can kind of give their suggestions in terms of, especially from the union's role representing the kind of boots on the ground officers. That sort of insight, I think, is critical into implementing a successful civilian review body. Like I said, the law enforcement personnel themselves are going to have the expertise and knowledge to make certain that the board itself is workable and not something that's just aspirational, which is what a lot of them unfortunately suffer from right now. So the next topic is that I think is kind of important to discuss is kind of a broad topic, but it's really collective bargaining and arbitration for law enforcement, and what that looks like, what that means. I think the union's job is not unlike a typical defense counsel. The job is to ensure that their client, which is the individual, in our case, officers, it might be teachers, firefighters, steel workers, are afforded due process and adequate representation. Unions have a fiduciary responsibility to represent their members. And the way that we've set this up in the United States, in most cases, is through the collective bargaining process, and the opportunity to then grieve via arbitration when something goes wrong, or if there's some sort of employment dispute. And I think kind of the slide that I have up here is something that kind of gets lost in the current narrative that's surrounding unions, is why we have them in the first place. And I kind of just put this in here as kind of a reminder of the role that unions truly play, and why they were established. And again, I'm coming from the law enforcement perspective, but unions exist for a lot of professions that make our society work: government workers, firefighters, teachers, steel workers. And one of the other narratives that I've seen and that I've read is the role that union plays in setting certain policies or in American politics in general. But I think more so, if you really look at it, than any public sector union, corporate America is probably who controls today's politics more than, especially today, more than any public sector union might. So that's something to just kind of keep in mind as we talk about the role of the law enforcement union. So collective bargaining, under these agreements, sometimes they're called memorandums of understanding or MOU. These are how the wages, hours, benefits of public sector employees are guaranteed, for the duration of the agreement. Again, these are on a state by state, sometimes municipality by municipality basis. The next slide here, this is probably the most important slide on this presentation, because it comes to the common misconception as it relates to unions. And I think this is especially true for police officers. So the union doesn't hire, they don't promote, they do not fire, they do not train, they do not discipline, they do not set the budget, they don't select equipment, and so on. All of those decisions go down to management. So I think it's difficult, at least from my perspective, to judge a law enforcement officer that's accused of misconduct when they have no authority in any of these areas, and then the finger gets pointed back at the union. Poor training or discipline or hiring of an unqualified, or as we hear, the bad apple officer, those aren't subjects of collective bargaining. So the union has no ability to control how departments can or should improve in these areas. So think about how many opportunities management has to weed out a bad officer before they even are fully operational in the department. So before hiring, the officers undergo extensive background checks. That includes psychiatric evaluations. There's a probationary period where the officer is at will, where even if they are represented by a union, they can be fired for any reason when they're at will. And then after that probationary period, again, the sole discretion to train the officer, to supervise the officer, to discipline the officer really rests with management. And again, when the budget is set, that's not, the union doesn't set the budget, and the first thing that when budget cuts usually happen is training, which is unfortunate. And so those are some of the issues and misconceptions about the difference between the role that management plays versus union plays. So what does that mean when we're talking about police reform? So when we're talking about reform efforts, if we understand these things to be true, what does that mean? I think what it means is that if you actually want to implement reform or modernization measures for law enforcement officers, I think talking to the command staff in the department is who you need to be talking to, not management. The officers that are actually directing the lower ranks know what sort of improvement needs to be made within a department. So find out from the command staff and then approach management with what sort of workable suggestions, policies, procedures, alternatives. That's, I think, sort of that step-by-step approach that if reform measures and modernization measures are going to be implemented, is a key step that I think we're sort of missing right now. So arbitration, just as a general matter, is the favored method of dispute resolution across every employment sector, and that includes public employers and private employers. I think the number is almost 62% of employers with between 1,000 and 5,000 employees have some sort of mandatory arbitration clause to resolve employment disputes. And so the point is that this is not a unique, arbitration is not unique to law enforcement unions. And that's for two really simple reasons, honestly. It's because it's timely and it's cost effective. If you eliminate arbitration and you force everything to go to litigation, from someone that litigates on a daily basis, if you file a lawsuit today, I can guarantee you in state court, you're not getting your trial before a year. In federal court, it's probably more like 2 years. And that's a quick route. So those are, honestly, those are two of the more, kind of simple answers as to why arbitration exists. And again, it's not something that's unique to law enforcement. The second key point to make here is that the number of arbitrated police discipline cases is relatively small. So what I mean by that is that the number of cases that actually go all the way to final decision by an arbitrator is very tiny. One study that we looked at showed it's like somewhere between 1% to 2% of cases. And when you think about it, that makes sense because unions do not want to take bad cases to arbitration because they don't want to set bad precedent. So they really only take the cases they believe they have a good shot at winning to arbitration. And that's true for any good public sector labor attorney. It's not something that's unique to law enforcement. So I think that's kind of a key point that doesn't get mentioned a lot, is how small the number of cases that actually go all the way to binding arbitration is. And as an aside to that, the decisions that do go all the way to final binding arbitration are typically resolved about 50-50. Sometimes it's for the employer, sometimes it's for the employee. So if you think about that, it's 1% to 2%, and then it's 50-50 once you get through that 1% to 2%. So it's even a lower percentage that get resolved in favor of the actual officer. So that's just kind of an interesting aside that I think, again, doesn't get mentioned super often. The third key point, I think, gets kind of to the heart of the issue, which is, so the question is always asked, how can a terminated police officer get his or her job back through arbitration? And the truth is, looking at a lot of these decisions, it's due to departmental mismanagement. So either they didn't follow due process procedures that are in place, or the department itself conducted, a shoddy investigation, essentially. The union's role in defending an employee's due process rights through arbitration is rooted in collective bargaining that is negotiated and approved by management. So again, I think if you keep that in mind, one, that the number of cases that go all the way to final binding arbitration is very, very tiny. And then when they do get turned over, which is about a 50-50 shot on that, it's because management messed something up during the investigation. So the last topic here, before we go into kind of a Q&A, that I'm happy to stick around, and my contact information is in here as well for any follow-up questions. But I think it's a good time to kind of talk about qualified immunity, just because it's a topic that's out there. I'll touch on it here, but the Supreme Court just came out with 2 cases yesterday, reversing 2 different circuits, the 10th and the 9th, that had denied officers qualified immunity. The Supreme Court reversed summarily on per curiam decisions, and granted the officers qualified immunity. So change, I don't think, on this issue is going to come from the Supreme Court anytime soon. So kind of, you know, that's just kind of a sort of my background, my perspective on it. But it's really a topic that a lot of people didn't have a clue what it was a couple of years ago. And now I have, you know, non-lawyer friends that want to talk to me about qualified immunity all of a sudden, which is, it's interesting, and I don't mind it. But, you know, I think within our discussion of qualified immunity, I think it's important to talk about state indemnification statutes, which exist across many states and provide statutory indemnification, not just to police officers, but to firefighters, to teachers, to mayors, to city officials, to administrators, to government officials. So this is not, one of the things I think that gets confused on people is qualified immunity is not just something that's for police officers. It's for any state actor, you know, operating under, you know, color of state law and their official capacity and their official duties. So I'll briefly go through kind of what the standard is here. And again, this is qualified immunity is a judicially created doctrine. So it's judge made, and it's applied when it's raised by a defendant in a case. So the defendant will have been sued for money damages in a civil action. And then the defendant can raise qualified immunity. And then the burden shifts to the plaintiff to show these two different prongs that are on your screen. The plaintiff has to show, one, that a constitutional right was violated, and then two, that it was clearly established at the time of the violation, such that a reasonable officer would have known that his or her actions were violating that constitutional right. And I think it's important to note in these two steps here, so if the answer is yes, then the officer is to both of these questions, step one and step two, then there's no qualified immunity. But the issue is the court is permitted to answer those questions in whatever order it sees fit. So this slide right here, step one, step two, is sort of a misnomer because the court can go straight to step two. It does not have to answer step one at all. If the court can find that the law wasn't clearly established at the time, then they don't have to answer the constitutional right violation. So, and I think that's the direction we see that the two Supreme Court cases that came out yesterday, that was the direction they went. They said, you know, kind of irrespective of if a constitutional right was violated, there's no way a reasonable officer at this time would have known that their actions were violating that law. So therefore, qualified immunity is available. So I want to talk just briefly about what clearly established means, because I think it's confusing for people. It comes in, and this comes directly from the Supreme Court. They said, a right is clearly established if it is sufficiently clear that every reasonable officer would have understood that his or her actions violate that right. Existing precedent must have placed the statutory or constitutional question beyond debate. Clearly established law should not be defined at a high level of generality and must be particularized to the facts of the case. So all of that is to say, I think it's really about notice for the officer or government, again, not just police officers, any government actor. You know, they need to have notice that what they're doing, their actions might be in violation of a particular statutory or constitutional right before you can hold them personally liable for civil damages. And we're going to go through here in a second kind of what qualified immunity does not apply to. And I think that's important. So just keep in mind that we're talking about personal liability for civil damages, for money damages, not anything beyond that. So again, when is it available? It's available in civil suits where the plaintiff is seeking, again, like I said, monetary damages directly from that individual. It's available to all state actors, government officials, police officers, management, teachers. And it provides absolute protection from civil liability. So if the officer or state actor is granted qualified immunity, they are removed completely from the case. I think this slide right here is probably the most important one when we're talking about qualified immunity, because it's sort of what the defense or what the doctrine does not provide. You know, keep in mind, we're talking about money when we're talking about qualified immunity. We're not talking about protecting individuals or officers that knowingly violate the law. So in those egregious cases, in the cases where the officer does something criminal, qualified immunity not available. So, and as I said here, it doesn't provide protection from criminal charges as well. So an officer can be criminally charged and they can't claim qualified immunity to get them out of those criminal charges. It's civil cases only. It also doesn't prohibit suits against the city or the municipality. So your case can still proceed against, even if the individual officer is granted qualified immunity, the city itself does not have qualified immunity. So a case can still proceed against the government entity. Again, it doesn't protect officers from internal investigation through the department, through termination or discipline. So in those internal affairs cases, an officer doesn't have qualified immunity available to them. It's a civil litigation doctrine only. And then again, doesn't apply to claims for injunctive relief or for actions that officers have to apply, those ministerial tasks. Again, like I said, the defense is not going to be available in really the most egregious of cases. And there was a case before the Supreme Court recently. It was this over the summer. It was called Taylor v. Riojas. And the plaintiff in Taylor was an inmate in a Texas jail. And the corrections officer in this Texas jail kept him in a cell that was covered nearly floor to ceiling in massive amounts of feces. And the court found that the officers should not be, this is the Supreme Court, found the officers should not have been granted qualified immunity because no reasonable correctional officer could have concluded under the extreme circumstances it was constitutionally permissible to house Taylor in such deplorably unsanitary conditions for such an extended period of time. So again, as I said, it's in the worst of the worst, the really, really bad cases, irrespective of if you have clearly established law or not, the court's going to get it right in those cases. The bad ones, qualified immunity won't be available to those officers. Again, like I said earlier, I don't think that the Supreme Court appears inclined to end the doctrine anytime soon. The two cases I referenced yesterday, they're called Rivas Villegas v. Cortes Luna, and then City of Tahlequah, Oklahoma v. Bond. We actually did an amicus brief in the City of Tahlequah case. Those were two cases where the lower court, actually the trial court in each of those had granted qualified immunity to the officers. The circuit court, Court of Appeals came over and said no qualified immunity to the officers, and the Supreme Court just issued their decisions yesterday, summarily, again, in a per curiam opinions, no dissents, that said that the law had not been clearly established to give the officers essentially notice that what they were doing violated those constitutional rights of the individual plaintiffs in those cases. And I think that's kind of the point, is that for those that are seeking qualified immunity through reform through the courts, the Supreme Court just does not appear inclined to revisit or end the doctrine anytime soon. So again, like I said, I think it's important in the context, especially of police indemnification, to talk about state indemnification statutes. And so this is the practice of the municipality paying what the officer owes, either through some sort of settlement or an adverse judgment. And I think it's important to talk about why these statutes exist across states. So Ohio, for example, they indemnify public officers or employees from liability incurred in the performance of their official duties for up to $1 million per occurrence. And again, I think we'll talk briefly sort of why these sorts of things exist. So the first point is that, and again, keep in mind qualified immunity as well when you're thinking about state indemnification statutes. States want to attract talented individuals to work for the government. And that's true not just in police departments, but any state, public office wants their the most talented people to come work for them. The US Supreme Court noted that is an important policy consideration as well. It was a 2012 case called Filarski v. D'Elia. They were deciding whether to extend qualified immunity to a private defendant that was acting on behalf of the government. And in holding that the individual should get qualified immunity, the Supreme Court said, without qualified immunity, the most talented candidates will decline public engagements in favor of other work that does not expose them to liability for government action. So, I don't know many people that want to expose themselves to personal liability for, essentially, doing their job. And so that would be the risk that you would have if these sorts of indemnification statutes start to disappear, or if qualified immunity starts to disappear. The fear of defending a civil suit compounded with that sort of risk of personal liability will, I think, dissuade a lot of people from becoming government officials in the first place. They'll, take their talents elsewhere, so to say. I think one of the other, and this next slide is an interesting point, is providing indemnification to the city executive leaders. Those executive leaders, the mayor, the city council, are sending kind of a message to law enforcement saying, we have your back, your work is appreciated. That improves officer morale, and it's a true. It's a truth. We defended some officers in a case a couple years ago. And it really bothered the individual officer to have her name on the front of this complaint like this. She did not like, her name appearing on a public docket as a defendant in a lawsuit for something she felt that she, did correctly and did her job in. And so having that backstop of indemnification sort of gives them support in those circumstances that I think is necessary. So the next one, so right now the liability costs typically fall to the municipality rather than the individual, and that is likely, assuming that stays true, that will overall reduce the number of constitutional deprivations that occur in the jurisdiction. And what I mean by that is, if attaching personal liability to an individual defendant is going to deter willful misconduct. So those individuals that may do something willfully may think twice before they do that, because they say, look, my pocketbook could potentially be on the line here. But most constitutional violations that occur in each jurisdiction are not the result of willful behavior on behalf of the officer. They're a result of, reasonable mistakes in judgment. So the other point is in qualified immunity isn't going to be available for willful misconduct anyway, as I said earlier. So it's kind of a to do away with these indemnification statutes and not place the liability on the municipality is kind of fruitless. And the other point to make here is that departments themselves are going to be equipped to review settlements and judicial determinations to identify these problematic behaviors and then determine steps to correct and reduce the number of these occurrences. So if a department gets tagged for a settlement or a judicial determination for X amount of dollars, they may say, okay, what went wrong here? What can we do to implement a change to our policy, a retraining of these officers, something along those lines? Departments are more equipped to look at those sorts of things and make changes. One of the last points here is I think important because I think we all agree that legitimate claims for injuries that are inflicted by a government official, whether that's a police officer, a mayor, a teacher, whoever it may be, should be compensated. People that are injured by by their work should be compensated. But in the absence of these indemnification statutes, plaintiffs are going to be left with a very few remedies. That's just the reality of it, because a lot of these individual defendants, police officers, are not going to have the personal means to satisfy any sort of substantial judgment against them. So you get a $200,000-$300,000 judgment against you. I don't know a lot of officers that are going to be able to satisfy that sort of thing, and so then they claim bankruptcy. And then, the individual plaintiff is ultimately suffers as well, because they do not get compensated for their injuries that they probably should be compensated for. So that's just something, kind of an unintended consequence to keep in mind here. So these are some of the reform measures that we've seen come about. There's federally, they introduced the George Floyd Justice and Policing Act, again, calling for an end to qualified immunity. This is just for police officers too. This has not passed, so this is not law or anything like that. It's just something that was introduced in 2020. Again, it just called for the end of qualified immunity just for police officers, not all government officials. So even, federally, they're recognizing that sort of distinction that they need to make if they're going to do that. Statewide, Colorado was really the first state to specifically negate the availability of qualified immunity as a defense through legislation. It created a $25,000 personal liability cap for officers. And again, it's just for state law offenses. So a lot of these cases, Fourth Amendment cases, are brought in federal court, and those are federal claims. So the state reform measures that you see here apply just to the state law claims. In looking kind of at reform efforts for qualified immunity from the law enforcement perspective, I think there's really two key points that you can kind of take away from this. First is that the chilling effect on officer misconduct that people are hoping for if qualified immunity is eliminated, or if these state indemnification statutes cease to exist, for example, for the officer to think twice before they act, I think is going to be relatively non-existent. In these split-second scenarios that you're asking an officer to act in, officers aren't thinking about qualified immunity. That's just the reality of it. If you ask them, that's what they'll tell you. And the willful misconduct that we see, the really, really bad cases are still going to happen. Eliminating qualified immunity as a means to prevent those is really fruitless, because it's already not permitted as a defense in those cases, as I discussed. The second point that I think is key is that there's retention and recruitment issues across the country that are plaguing departments, and it'll only get worse if qualified immunity or if these state indemnification statutes start disappearing. And I think that's something to keep in mind as well, is we want the best police officers out there patrolling our communities. And if you have trouble recruiting and retaining the more seasoned and the more talented officers, I don't know that helps any of our issues. So again, kind of circling back to the point that the union and the officers want a role in police modernization reforms. They want to be consulted. They want to be given the opportunity to weigh in on measures that impact their duties and responsibilities. And I think if we want to create meaningful reform, and from the national FOP perspective, we don't oppose that. But if we want to create reform that really works, having that sort of discussion with the individual officers or the union that represents them will be really critical in kind of advancing those sorts of measures. So with that, I'll say thank you, and then I'll stick around for any questions that anyone might have. Again, here's my contact information. Feel free to shoot me an email or give me a call. I'd be happy to discuss anything offline as well. But thank you all very much for your time today.
Mita, you're on mute.
Thank you, Chris.
Absolutely. Thank you.
Can you stop sharing your screen?
Yes.
Okay. Do we have any questions from the attendees? Well, I have one.
Go ahead.
And it relates to more of the backlash that's resulting from all the issues related to police misconduct. And I was just questioning and wondering about the stats on your hiring pool, because a lot of officers are now leaving their positions.
Yeah, I mean, as I said, that's a huge problem. I have actually was just looking at kind of some police recruiting research that we have. We have 8.5% of current police officers are eligible for retirement right now. Another 15.5% are going to become eligible for retirement within the next 5 years. We have places like Seattle reported a 40% drop in applications. 86% of police chiefs nationwide are reporting a shortage of police officers. So it's a major issue right now. I think we are having, in terms of not just recruiting, but retaining the more seasoned officers. There's officers that have been in the force for 25 years that just say, you know what, I've had enough of this. I can go get a job somewhere else and not risk, not only my life, but my house, my kids, college funds, things of that nature. So it's a major issue. It's something that we're tracking and that we have discussions at the national level all the time. So I appreciate you bringing that up.
Now, Chris, are there any trends in collective bargaining itself and the arbitration process? Because I know there's some reform efforts to want to allow the civil review boards to come into the arbitration process itself, to the actual hearings, and making them more akin to judicial-like proceedings.
Yeah, I mean, that's obviously one of the things that we discussed when we were kind of making our recommendations for civilian review bodies and what sort of role they might have in the arbitration. I mean, I think our idea, I give a lot of pushback in allowing the civilian body to have any sort of role in that independent arbitration hearing or anything like that. I think the recommendation, as I said, that we made at the national level was to, if these civilian bodies, want to have a say and want to have true reform, that needs to come more from an auditing perspective, auditing different investigations and problems that we're having. So I don't necessarily think that, we would. I haven't seen anything where we're seeing these civilian-led bodies kind of, infiltrate, I guess you could say, the arbitration proceedings. We would encourage keeping those as independent as possible. And again, as I said, bearing in mind the incredibly small amount of cases that ultimately do go all the way to final binding arbitration as well, I think is super important to keep in mind.
Thank you. Are there any other questions? Well, we want to thank you again for the great session. The information was truly informative.
Sure.
Dawn will be sending you our coveted cups from COLERA.
Wonderful, wonderful.
Just our appreciation.
Sure.
I would ask all the attendees to mark your calendar for next month. We'll be having the National Labor Relations Board Regional Council giving us updates on the board. Chris has also put into the chat the survey form that must be completed if you're seeking your CLE credit. Chris mentioned, let me see, I think I put it up there. I put it, his website, I mean, his presentations there, but also the website for the NCSL. Is that what it was, Chris?
Yeah, the National Conference of State Legislatures, they have a great database that we use here to kind of track things. So absolutely, I'd encourage everyone to go check that website out.
So that's also in the chat.
A quick reminder, if anybody has not placed their name and attorney registration in the chat message twice, please enter it a second time at this point. Otherwise, you will not be receiving credit. Thank you.
Okay. Have a wonderful day, everybody.
Thank you all. I put my information in the chat too. If anyone wants to chat offline, shoot me an email.
Anita,
Yes, Gary.
Thank you all.
I went to the forum for the rate, the